Hello everyone, I'm Sumit Chander advocate and I am going to teach you legal drafting. But before I begin, I must appreciate Desi Kanun for providing this platform through which I am able to present to you how to do legal drafting and why legal drafting is no rocket science. To begin with, let us understand pleadings. Pleadings have been defined under Order 6, Rule 1 of the Code of Civil Procedure as the plaint and the written statement. Of course, in due process, replication is also filed if the court so permits. A replication, my friends, is a reply to the written statement. But let us understand the court procedure to understand as to how to do pleadings. It is important for us to know as to what goes on in the court. So let's go step by step. It begins with the plaint. Whenever a person has an issue, a civil issue in this case, because we are talking about civil drafting here, the plaintiff would file a plaint laying down the issues that he has had, the problems that he has faced against the defendant, and the relief he seeks to claim against the defendant. If the court finds it fit to be admitted, the court will admit the case and issue summons to the defendant. The defendant will then, within 30 days of receiving the summons, will file his written statement. Once the written statement has been filed and some new facts have been given in that written statement, the court may give the plaintiff an opportunity to file a reply to the written statement, which is called the replication. After this, officially, the courts say that the pleadings are complete. Once the pleadings are complete, then the court puts it for affidavit of admission and denial. This has been defined in chapter 7, where both the parties, in order to facilitate and make things faster, are given the opportunity to admit or deny the documents of the other. If the documents of the other side is admitted by either of the parties, then that becomes admissible as an exhibit in the case. Once the admission denial process is over, the court then puts it for framing of issues. Now, what are issues? It's very simple. Wherever an assertion is made by one party and denied by the other, it becomes an issue. It is these issues which is eventually going to be decided by the court. So the court would go through the documents, the pleadings filed by the parties, and thereafter decide the issues. Now, while deciding the issues, or the issues on which the court would finally adjudicate upon, the court would also make a mention that which issue is to be proved by whom. Commonly, the person making an assertion will have to prove his issue. So after every issue, the court will put down by 3 letters, which is called OPP or OPD, which means onus of proof on plaintiff and onus of proof on defendant. So it will become very clear as to which party, the plaintiff or the defendant, has to prove which issue, which will eventually help the court decide the case. Now, once the issues are framed, both the parties are now aware what they are to prove by way of witnesses and by way of documents, would then begin the evidence. Evidence will begin with the plaintiff's evidence first. Plaintiff will file his evidence in chief by way of an affidavit. Once the evidence by way of affidavit has been filed by the plaintiff, the defendant's counsel will be given the opportunity to cross-examine him. And similarly, the other plaintiff's witnesses would come. Once the plaintiff's evidence is complete, the defendant would be given an opportunity to file his affidavit in evidence, and the plaintiff's counsel will be given the opportunity to cross-examine him. Once the evidence is complete of both the plaintiff and the defendant and their witnesses, the case is listed for arguments, and after hearing the arguments and relying upon the evidences which have been proved by both the parties, the court will pass its judgment. Now that the procedures are clear, and this is of course a very basic procedure, there are more detailed applications and other things which go on in court, but overall this is what is the Code of Civil Procedure in short. Now coming to the drafting of the plaint. You've understood there are various pleadings. Now we are talking about drafting of the plaint, which is filed when you're preparing the case, or where after filing the case the plaintiff is to file the plaint. Now drafting of the plaint is very important because this is where you're creating it. In fact, this is where the talent, your talent as a lawyer, as a budding lawyer, comes into picture. Now once you understand these 5 stages of preparation of a plaint, you will realize it does need hard work, but it is no rocket science. A little bit of hard work from your part will help you do this drafting very nicely. Stage 1 is paper sorting. I'll explain it later. Stage 2, client meeting. Stage 3, legal research. Stage 4, rough draft. Stage 5, final draft. Friends, do keep in mind, eventually everybody evolves their own way of drafting. This process of drafting has been devised by me over the years of experience in this profession. Stage 1, paper sorting. Now, interestingly, what happens? Whenever a client comes, he leaves a bundle of papers with us. Now, at this stage, what I expect lawyers to do, and which I have been doing myself for many years now, is put the date of the document on the top right corner of each document. Generally with pencil, because you need to remove it later. Once you put these dates, and dates are always sorted with the oldest on the top, and that's, in fact, I would like to bring it to your notice, that sorting of papers of a legal file as compared to any other corporate file is different. Generally in every other government file or a corporate file, the latest document will remain on the top. In a legal file, the latest document will always remain at the bottom. Because when you read a set of documents, you read it like a storybook with the oldest first and goes on to the latest at the bottom. Now once you've prepared and dated each document, you put these in a manner of a list of dates and events with the source of that document. So you'll now have to study each document, and there will be various stages in which you study. So in stage 1, you focus on the date of the document. Why this date of the document is important? It will look easy, but generally, a lot of people make a mistake on the date of document. Why? Let me give you an example. Supposing a date has been given on the top left corner and a different date is given at the time of signing of the document. At this stage, you need to figure out which is the date you're going to put in your list of dates and events. Similarly, Once you've put the list of dates, you also need to tell the source. Is the source a letter or an email or maybe some document or a deed? So that is where the source come into picture. Then you call the client for a meeting. Now when the client comes for a meeting, by this time you are already prepared, having read his documents and made the list of dates and events. You are sure that the documents don't lie. So you're very confident, but the documents don't give you the exact clear picture because some documents might be missing, which now the client will discuss with you and tell his story with his dates or what he remembers best. Interestingly, when a client comes to us and he tells the dates, generally those dates don't match with the dates of the documents. In fact, it has happened several times where you will tell the client that, sir, you are saying that so and so incident happened on this date, but your document says otherwise. Now, that stage, the client will then tell you, oh, I'm sorry, Mr. Counsel, I forgot. Yes, you are right, the document cannot lie. And accordingly, his dates will change, but what he will do is, he'll help you fill in those blanks which were in the middle of the documents you were not able to relate. Now the storyline has to be complete, so you will make a note of his list of dates and fill in the gap in your current list of events. So now you got exact dates from the documents, you've got approximate dates or months or even a year from the story being told by the client, and once with this you will be ready with a approximate sketch of the story in mind. Now once the story or the factual story made down by the list of dates is ready with you, you come to stage 3, which is legal research. Now you've understood the facts and you've given the opinion to the client that, okay, in your case maybe a recovery suit is made out because you need or you want to ask the court for the relief of money from the defendant. So you look for cases or the relevant provisions of law which will talk about the recovery. Once you have made or read those relevant provisions of law, and I would recommend strongly that every time you do a drafting, you must read the relevant provisions of law under which you are making the plaint. So once you've read the provisions of law, you're going to break that provisions of law, that section, and make the or segregate the ingredients of the law, pointers of course, and you would know exactly whether whatever is the requirement or the ingredients of that section, have you been able to cover that in your drafting? Now you've got very clear with the law, you've got very clear as to the ingredients of the provision, and you're very sure that you've incorporated those provisions in your facts. Then you read the relevant judgments or the precedents by the High Court or the Supreme Court. Now judgments and precedents from the High Court in similar matters would obviously describe certain issues, and the High Court or the Supreme Court would in some manner or the other would have said that a case is made out if so and so incident has taken place. Now those incidents become important. Your facts may already have them. If they don't, please incorporate those. Copy relevant paras from those judgments, at least the legal paras, and make it part of your pleadings. Stage 4, which is the rough draft. Now you have a final list of events in hand, and you take a format of a similar draft which you intend to make. Change the title. Draft the paras introducing the plaintiff and the defendant. Once you've introduced the plaintiff may be a citizen of India and who met the defendant in a particular manner and is aggrieved because he took the money. The defendant is a businessman who somehow showed you that there is loss going on in his business for which he needed money and he borrowed that money from you, which today he refuses to return. And after that, you get into the facts of the case, which you have already prepared in your list of events. But of course, now you put it in a story mode. And the last, after the facts, you need to put the mandatory paras. Of course, as per the facts of the case. Now, what are these mandatory paras? Let us understand. Mandatory paras have been described under Order 7 CPC. Mandatory paras include the cause of action. So, for example, in your facts of the case, you have to explain as to how the cause of action began. He had, of course, taken the money, then he refused to give you that money. Your cause of action accrued in your favor because now you had the right to claim, a legal right to claim that money from him. Because after the expiry of a certain date till which you had given the money, he has not given that money to you or refused to give that money to you, the cause of action arises in your favor. Then the territorial jurisdiction. Under which jurisdiction or which area did the incident take place? What incident? Your cause of action. Where was the money given to him? Or where did he refuse to give you the money? Or maybe where he gave you money by way of a check but the check got dishonored. That area where any of the part of the cause of action or the whole of the cause of action has accrued will become or define your territorial jurisdiction. Then the pecuniary jurisdiction. What is the value of your suit? Accordingly, it will be defined as to whether your suit will go before the district court or the high court. Interesting fact for all of you, not all high courts have original jurisdiction. Say for example, Punjab Haryana High Court does not have a original jurisdiction. No matter what the value of the money, it will remain and go to the district court first. However, in High Court, if your value of the suit is more than 2 crores or maybe you're asking for a recovery of more than 2 crores or a property dispute where value of the property is more than 2 crores, you can directly file the case, a suit in the High Court. Then comes the limitation. For every suit, there will be a limitation prescribed under the Limitations Act. Say for example, in a recovery suit, which we are discussing here, would be a limitation of 3 years from the date of the cause of action. I've already explained the cause of action to you. Then comes the value of the suit and the court fees are fixed. Obviously, for the pecuniary jurisdiction, you've already calculated and valued your suit as to what amount are you finally, which is the relief you're claiming, and accordingly, you have to calculate the court fees as per the Court Fees Act and affix it. And the last para is your prayer. So, after your facts of the case, you need to be very clear about the mandatory paras and put them after your story or your list of dates in a story form has been put. The prayer, my friends, is very, very important and you should always keep this in mind. In fact, I can give you an example here. Many years back, there was a consumer case I was appearing. I was appearing for the company. There was a refrigerator in issue. What had happened was, in the consumer case, the person was very aggrieved that his refrigerator was not working. So the court asked him that the case will take time, but would you like to settle? And if you would like to settle, what do you want? He said, Manoj, I want to teach them a lesson. The appearing for the company, I said, that's okay, but I'm not still very clear. Does he want a replacement I can offer or a refund of the refrigerator? So the judge again asked him, what do you want? Here the consumer was appearing in person. He was not appearing through a counsel. So he was very agitated. His emotions were flowing. And he said, I will not leave them. I teach them a lesson. This went on for 3-4 times. And finally the judge said, I think he's not very clear as to what his prayer is. So the case continued. Settlement did not take place. So you should be very, very clear from the time of drafting of the plaint what your prayer is, what do you want to seek in that case which you're filing. Then comes the final stage, which is the stage 5. Now you have your complete file, you have your rough draft and your list of dates and events. Give a final reading to your draft. Check for a clear storyline and grammatical errors. Ensure that all ingredients of law are fulfilled, which were those mandatory paras under Order 7, which I just explained. Add the relevant paras from the precedents. Ensure that there is no missing link. The storyline has to be complete, one after the other. It should make sense. You cannot have an incident which is not related to the para before. Make the supporting affidavit, which is Order 6, Rule 15, Sub-Rule 4. Now, supporting affidavit is very, very important. One, for two reasons, I'll explain. One, that it is a requirement under law, under Order 6, Rule 15, Sub-Rule 4, as I've already said. And secondly, it somewhere protects the lawyers or protects you as a lawyer who has drafted this plaint. Because the contents of this affidavit says, which will be the plaintiff himself whose affidavit will go, will say that the contents of the accompanying plaint has been drafted by my counsel under my instructions and contains true statement of facts. He takes the entire responsibility of the contents of the plaint. Not only this, supposing he tomorrow comes up with a plea saying that, I don't know, sir, the lawyer drafted it, I don't even know how to read English. I just signed where the lawyer asked me to sign. So we also write in that affidavit that the contents of the accompanying plaint and this affidavit have been read out to me in my vernacular language and has been understood by me, and that is why I am signing it. So overall, there are a few basic points you need to keep in mind. First and foremost, keep your language simple. In fact, the most difficult thing to do is to keep it simple. When I say language simple, I don't only mean that you need to keep your simple words or use simple words. I also mean that your sentences should be something which even any common man who does not know any facts of the case should be able to understand. Secondly, there should be no repetitions. Third, use words as much as possible from the documents and judgments, because if tomorrow in the court you've used a word which does not make sense and the judge will ask you, why do you call this document XYZ? Then you can clearly tell the court that, sir, this is not a word which I have imagined. This is a word which is there in the document, and if I have to prove a document, I have to use the words of that document. Fourth, avoid long sentences. The longer the sentence, the chances are that you will miss out on the expression of what actually you want to say. And last but not the least, I've already explained to you why your prayers should be very, very specific. So with these things in mind, if you go on with your drafting, I can assure you your drafting will definitely come out very well. Thank you so much.